legal counsel for UNM Rainforest for about 30 years. And I'm going to speak to you this morning about intellectual property license and option agreements. And even though I represent UNM Rainforest Innovations, this morning my presentation is basically my comments. They're my own and they don't necessarily represent the views of UNM Rainforest Innovations. And as Celia said, if you have questions as we're going along, go ahead and raise your hand or write a chat note to Celia and we'll try to address those as we go along. The presentation this morning is going to cover 5 areas. We're going to start with a discussion of the subject matter of the agreements, a little background about patents and copyrights. I think it's important to understand a little bit about those because it'll help you understand how they apply to a license agreement and how we use that in doing our licensing transactions at UNM Rainforest. Then there'll be one slide that shows the usual transaction timeline. Then I'll go into a discussion of the license agreements themselves, followed with the discussion of the option agreement, and then I'll have some additional thoughts. So it made sense in thinking through this to talk about the license agreement before the option agreement because it's helpful to understand what a license agreement is and what it does before we talk about what an option to acquire a license is all about. So intellectual property license agreements have basically 4 major categories of intellectual property that they're used to license. The 4 primary types of intellectual property in the United States are patents, copyrighted materials, which include software, trademarks, and trade secrets. This presentation this morning will focus primarily on licenses for patents and trademarks. Those are the most common subjects of licensing transactions, and especially the most common here at UNM Rainforest Innovations. So IP protection in the United States has its basis in the United States Constitution. On the slide now is the section of the United States Constitution, Article 1, Section 8, that gives Congress the power to provide protections to authors and inventors for their writings and discoveries. Congress has provided patent protection by statute, with the first patent statute was passed in 1790. The first patent was issued to a guy named Samuel Hopkins of Pittsfield, Vermont in July of 1790, and his invention improved the making of potash and pearl ash by a new apparatus and process. If you take a couple seconds to read this portion of the statute, you'll note that the powers granted to the patent owner is a negative power. It's not the power of the patent owner to practice the patent, but it's the power of the patent owner to exclude others from practicing the patent. It's a small difference, but I think it's important to understand that a patent owner has no affirmative right to practice his patent. His or her right is only to exclude others from making the invention. The next slide shows the general copyright statute. This statute was passed by Congress in 1790 as well. It gives the copyright owner the exclusive rights to do certain things with a copyrighted work. Basically, it allows he or she to control the distribution and reproduction of the copyrighted work. So for patents, the ownership rights are the right to prevent others from practicing the invention. And for copyrighted materials, the ownership rights are the exclusive right to use the copyrighted work and or to authorize others to use the copyrighted work. This next slide talks about how an owner may use or exercise his or her patent or copyright rights. The owner of the patented or copyrighted material or invention can exploit the creation by themselves. They could transfer ownership rights, outright ownership of the patent, invention, or copyrighted materials to others. They could give permission to others to practice or use the invention or copyrighted material in the form of a license. That's what we're talking about today. The owner could combine the first and third and use the invention itself and authorize others to practice or use the invention. Owners also have a fourth option. They could actually do nothing, and they could prevent others from practicing the invention or using the copyrighted materials, but not use them themselves or allow anyone else to use them. So this is a one slide that shows a common transactional timeline, and it'll help us to understand the relationship between the option and the license agreement, even though we're going to talk about the license agreement first. The normal transactional timeline is the creation of an invention or a copyrightable work. Then a potential licensee of the copyrighted work or invention may acquire an option to acquire the license. And if they exercise the option, then the licensee acquires a license to practice the invention or to use the copyrighted works. A little bit about what a license agreement is. Even though the patent and copyright laws are federal laws, a license agreement is a contract governed by state law. That was actually memorialized in a Federal Circuit Court of Appeals case in 2003 that involved the University of New Mexico. In that case, the state laws on the transfer of copyright of intellectual property were held to apply to confirm the university ownership of IP developed at the university. A license agreement is a contract that sets out the rights, powers, duties, and responsibilities with respect to the subject matter, a patent or a copyright, as between the owner as licensor and the other party as the licensee. This slide reflects the major elements of a license agreement, and you can read through those. We're going to talk about each one separately. I'll just give you a second to look through those. So obviously, if you have a contract, one of the key elements is the identification of the parties. In a license agreement, the owner of the intellectual property, the one giving the rights to the other party, is generally referred to as the licensor. The party obtaining permission to use is the licensee. Another obvious important element of a license agreement is the identification of the licensed property. For patents, it would be a reference to the issued patent, a patent application, or a description of the invention itself if no patent application had yet been filed. For copyrighted material, it would be a reference to the written material, usually code or software, and that may or may not be registered at the United States Copyright Office. And if it were registered, there would be a reference to the copyright registration number. On the screen are two examples of what the identification of licensed property looks like in rainforest license agreements. There's a reference to the technology number assigned to the IP by UNM Rainforest, the name of the invention, the inventor, and the date on which the application was filed or the date on which the patent itself was issued. Excuse me. The heart of the license agreement is really the granting clause, and that's a separate clause that contains language similar to the licensor grants to the licensee and then goes on to describe the scope and parameters of the license. The license could be exclusive or non-exclusive. It could be a field of use license. It could be a territorial use license. But the granting clause is really the one of the more important clauses in the agreement, and sets out clearly what the rights of the licensee and the licensor are with respect to the invention or copyrighted material going forward. One of the key elements of the license agreement is whether it's an exclusive license or a non-exclusive license. An exclusive license gives the licensee the most rights and is a promise by the licensor not to practice the IP itself, and it's a promise by the licensor not to sue the licensee for infringement of the intellectual property. And thirdly, it is a promise not to grant any further licenses. One of the interesting things, misconceptions people have about license agreements is that an exclusive license is a license that if you have an exclusive license, it means other people might not have any licenses. Technically, from a legal standpoint, all it means is that the licensor won't grant any further licenses to the IP. So if you're a licensee, you want to make sure that if you want a truly exclusive license with no one else having any rights, you want the license agreement to also promise or represent that the licensor hasn't previously granted any rights or licenses to the IP. A non-exclusive license is useful in some circumstances. It's not as common as the exclusive license, but it is a promise by the licensor that it won't enforce the licensor's patent or copyrights against the licensee. So it's a mere promise not to sue the licensee for infringement of the licensor's patent or copyright rights. The exclusive license generally allows the licensee to sublicense rights to others, whereas a non-exclusive license generally would not allow others to sublicense the rights to others. The thinking behind that is, if it's a non-exclusive license, anybody else wanting a license will come to the licensor directly for the license as opposed to going through another non-exclusive licensee. Whether it's exclusive or non-exclusive, even in an exclusive license, the licensor often reserves rights to use the IP for certain purposes. For example, UNM Rainforest Innovations in their license agreements reserves rights for the University of New Mexico to use the IP for its internal research, development, and education. And if the IP was developed with federal funding, the license agreement needs to make sure that the government rights under the Bayh-Dole regulations are reserved. Another type of license is a field of use license. This would divide the rights to use the IP or among different markets or applications. It allows the licensor to grant multiple exclusive licenses to non-competing licensees in different fields. For example, if the licensor had a novel battery technology, the licensor might give an exclusive license to one party to use in consumer goods, an exclusive license to another party to use for automobile manufacturing, and a third license to an entity for space applications. This enables the licensor to maximize its return and consideration for the license, and gives the licensees the rights they need to pursue the exploitation of the commercials or the exploitation of the IP in the areas in which they compete or manufacture and do business. There's also a possibility to geographically limit licenses. The licensor could divide rights among different geographic jurisdictions. This would allow the granting of multiple exclusive licenses to non-competing licensees in different countries. For example, you could license exclusive rights to certain intellectual property in the US and then license the same rights exclusively to a party in Europe, and finally license them exclusive to a party in Asia. I see there's something in the chat, so let me look at that. Oh, thank you. You're welcome. It was a compliment. Sorry, I'm having trouble going between two screens here. So now let's talk a little bit about the consideration for a license. There are numerous forms that consideration for the license can take, and it's a provision and a negotiating point that is of considerable importance to both the licensee and the licensor. The next few slides will discuss the different types of consideration that the licensee might obtain, that the licensor might obtain for granting of the license. The license might provide for an upfront fee, which would be an amount payable to the licensor at the signing of the license agreement. The license agreement might also include license maintenance fees and minimum annual royalties that are payable annually to keep the license agreement in force. These type of fees really have two purposes. First, one of the things that the licensor does not want to have happen is to license the IP to a third party and then have the third party sit on it and not do anything to exploit or commercialize the IP. Believe it or not, there are certain entities that would license IP for no other purpose other than to keep it under wraps and not have it compete with other IP that they own. The purpose of the license maintenance fees and the minimum annual royalties is to require the licensee to make annual payments, to the licensor, even though the licensee may not be selling products. In addition, the license maintenance fees and minimum annual royalties provide a return to the licensor where the license agreement has IP license that maybe isn't ready for the market yet and will take a few years to develop and start selling products to generate royalties on product sales, which is the next form of compensation that most license agreements include, is an earned royalty on product sales, which is a percentage of the licensee's gross income from products covered by the license. Different types of IP have different percentages of gross income that the royalty would be paid on. Generally, it's somewhere between 3 and 10%, usually for most products, and that is a running royalty that's paid to the licensor on an annual basis. If you remember, in an exclusive license, the licensee could also sublicense its rights to a third party to sell licensed products covered by the license agreement. So the consideration for the licensee or for the license would also include that the licensor gets a share of revenue earned by the licensee from its sublicensing activities. That percentage generally runs between 30 and 50% of the revenue that a licensee might get from sublicensing. The reason it's higher is that the licensee, by sublicensing, frees itself of the obligations of manufacture and marketing and pushes that off onto a third party and just becomes a passive recipient of income. And in those cases, the common thinking of the licensors is that the licensor is entitled to a higher share of that, since the licensee is not actively pursuing the commercialization itself. A license agreement might also include a milestone payment, which is an amount payable to the licensor upon the achievement of certain defined events leading to success in the commercialization of the intellectual property. For example, there may be a payment of a set amount payable to the licensor if the licensee obtains FDA approval for marketing of products covered by the license. Achievement of certain sales goals might also trigger a milestone payment. Generally, they are negotiated to allow the licensee to share in the success of the, allow the licensor to share in the success of the commercialization efforts of the licensee. Other types of consideration include a change in control payment. This would be a payment of a set amount made to the licensor in the event that the licensee is acquired or goes public. In UNM rainforest licenses, UNM Rainforest Innovation often takes a small percentage of equity of the company if it's a small startup company. This again provides an upside for the licensor in the event that the company is highly successful. Those percentages or equity positions generally are limited to between 5 and 10% of the company and are limited to amounts. They are capped at certain revenue or certain investment ceilings, so that the amount really is a small equity piece and is really intended to provide just a little kicker for the licensor in the event that the company is successful. Finally, the reimbursement of costs incurred by the licensor for obtaining and maintaining patent or copyright protection is always included in our licenses. One of the things that UNM Rainforest Innovations does is pays up front for the costs of patent prosecution, and that can be quite expensive, and that needs to be recovered. And so those are the elements that we generally provide for as consideration in our licenses, and that's normally what's covered in most license agreements. Now, you'll note that there's a number of different types of consideration, and as I think I might have said earlier, a license agreement is a negotiated agreement between the parties, and there is room for negotiation as between, for example, the amount of the upfront fee versus the amount of equity given to the licensor. The amount of the royalties on product sales may vary depending upon the type of, upon the amount of revenue earned by the licensee. The point is that these things are all negotiable, and it's meant to provide a fair return to the licensor while still incentivizing the licensee to be successful in the commercialization of the property, of the intellectual property. Since there are provisions that provide for payment and require an analysis of the activities of the licensee, there's a number of administrative obligations that are included in the license agreement. The license agreement the licensee is required to provide reporting to the licensee about product sales, licensing activities, sub-licensing activities. Usually those reports are due annually. With the reports, the license agreement requires that the licensee make payments, any payments due to the licensor under the license agreement from product sales or sub-licensing activities. And then finally, the licensee is required to maintain financial records for a period of time related to the license agreement and its activities under the license agreement. And the licensor is generally allowed to come in and audit those records generally once a year if they choose to do so, in order to make sure that the licensee is reporting accurately the amounts due to the licensee. Another provision in our license agreements is will define the rights and responsibilities of the parties with respect to control over the prosecution of patents. Generally, the licensor will want to retain the right to control the patent applications, but the licensee is given the ability to provide input and suggestions. the license agreement will also govern what the rights of the parties are with respect to dealing with third-party infringers of the IP. Generally, the license agreement will allow the licensee to be the first one to pursue infringers of the IP that it's licensed, with the caveat that if the licensee chooses not to pursue infringement again by a third party, the licensor will have the right to do so. Like any contract, the license agreement will usually contain warranties and representations by the parties. The key takeaway here is that the representations and warranties given by the licensor have to be limited. They will generally disclaim warranties about the validity or the enforceability of the patents or the copyrights. They will also disclaim any warranties or representations that other rights are not needed to exploit the licensed IP. Remember, for patents, the right of the licensor, the right of the patent owner is to exclude others from exploiting the licensed IP. It doesn't give them the right to exploit the licensed IP. So, for example, in an automobile, there are thousands of patents that are used in the manufacture and sale of the automobile. Any one patent doesn't allow the party to sell the car. The owner of that patent couldn't, for example, represent that the license would allow the licensee to make and sell cars. It would only allow them to be prevented from being sued by the holder of that license or that patent for the use of that IP in the manufacture and sale of that car. And finally, we can't warrant or represent that the IP will meet the needs of the licensee. Generally, the license agreement will require the licensee to understand the patent itself, understand the needs of its business and commercialization plan, and make its own determination about whether the IP is necessary or helpful in the operation of that licensee's business. In addition to the warranties and representations, the license agreement will almost always include an indemnification provision. The licensee is going to have to indemnify the licensor for any third-party claims that are made against the licensor arising out of the use or exploitation of the IP by the licensee. The combination of these disclaimer of warranties and indemnification provisions generally puts all business risks related to the commercialization of the IP on the licensee. That, of course, is factored into the cost of the license by the licensee and how much the licensee is willing to pay for the rights to the IP. But the idea is that the licensor is merely a passive holder of the license, and it's the responsibility of the licensee to take all actions necessary for the commercialization and all risks related to the commercialization of the IP. Another important element of the license agreement is the term. The term of a license agreement is negotiable, but by law, a patent license agreement, for example, can't exceed the life of the term of the patent. Normally, almost all the license agreements we see continue for the term of the patent, which the current law provides for 20 years from the filing date generally, or the copyright term, which could be more than 120 years. Excuse me. The license agreement will also provide provisions about when one party might terminate the license agreement. Our license agreements, almost every license agreement would allow for the licensor to terminate the license agreement upon a default by the licensee, and that would generally be a default in payment of either royalties or some other payment owed to the licensor by the licensee under the agreement. In our license agreements at UNM Rainforest, we provide that the licensee is able to terminate the license on written notice of a specified number of days. Once that notice is given, the licensee is still obligated for the number of days that is included, usually 90 days. And then after that, the license is terminated and the rights of the parties end. The licensor is free to go out and try to find another licensee for the IP, and the licensee is free of any obligations under the license agreement that has been terminated. So as in any other contract, the license agreements include a number of other provisions. One of the key elements of a license agreement is the definition of defined terms. Our license agreements are generally around 20 pages long, and about 3 pages of those agreements are defined terms. They are used throughout the agreement, and having a section that defines the terms, that makes it easier for people to go back and determine what term is being used in what sense. The defined terms will include things like maybe what a FDA approval is for a milestone payment. It could include terms dealing with when royalties are first due, for example, when there's the first commercial sale of a product. And generally it will include all the terms that are used frequently throughout the agreement in one place. There'll be provisions about assignment by the licensee. Generally, the license agreement will be assignable by the licensee in the case of a merger or acquisition without the consent of UNM Rainforest. It will not be assignable in other situations without our consent, because in some cases we want to be able to control who our licensee is. The licensee agreement will also contain provisions about governing law, jurisdiction, and dispute resolution. We, in our license agreements at UNM Rainforest, the governing law has to be New Mexico law because we are a quasi-state institution and we need to adhere to New Mexico law and jurisdiction because of that status. There'll be other boilerplate provisions in the license agreement that include notice provisions, dealing with export rights, compliance with export rights, export laws, and just the normal boilerplate provisions like severability and entire agreement clauses that you would find in most contracts. I'm going to pause here and take a look at the chat. The question here is, I looked up indemnity because it is a commonly used word, but I was unsure about how it applies here. So an indemnification is a promise by a party to protect another party if that other party gets sued because of something that the first party did. For example, if the licensee under a license agreement manufactures a product that harms someone, the person harmed might sue the licensee, but it could sue the licensor as well. Anybody can sue anybody these days, and the licensor wants to have protection against lawsuits from third parties that are dealing directly with the licensee as opposed to directly with the licensor. So if the licensor were sued by a party injured because of something that was done by the licensee, the indemnity provision would require that the licensee handle that lawsuit on behalf of the licensor and pay any damages that the license or incurred as a result of the activities of the licensee. So I hope that helps answer that question. So going back to the timeline of transactions, we have the creation of the IP, we have talked about the license agreements, and now we're going to talk a little bit about the option, because what the option is really a right of a party to acquire a license agreement. Option agreements are used when a prospective licensee may not quite be ready to commit to a full license agreement. The prospective licensee might need time to evaluate the IP or the market. The IP itself might not be fully developed, and maybe a provisional patent application has been filed, but the licensee may want to wait and see what the actual full patent application looks like before committing to license the IP. An option agreement is a contract, and it's a promise by the IP owner not to license the IP to any other third party for a specified period of time. So the prospective licensee would come to UNM Rainforest and say, I'm interested in this intellectual property. I'd like to consider licensing it, but I'm not quite ready to sign a license agreement. I'd like to option it so that nobody else gets the rights in front of me. And for a specified period of time, I'd like to be able to think about whether or not I might want to enter into a license agreement. The person holding the option is called the optionee, generally has a right under the option agreement to exercise the option and proceed to a license agreement anytime before a specified option expiration date. Generally, UNM Rainforest gives options in 6 months increments. Those can be renewed for some period of time, although we don't generally allow someone to tie up technology for more than a reasonable amount of time before they actually exercise the option and move on to a license. The option agreement might include reference to an attached term sheet that describes the general terms of the license agreement, including the consideration to be paid under the license agreement, the field of use, the exclusivity versus non-exclusivity, and the term sheet could cover anything that the parties had essentially agreed upon that would be in the license agreement at that time, but again, neither party is quite ready to proceed to a full license agreement. The option agreement also might attach a copy of an actual agreed upon form of license agreement. In this case, the optionee wants to not only preserve its option to acquire the IP, it likes to preserve its option to acquire the IP on certain agreed upon terms. So it's possible that the option agreement might include all the terms we talked about earlier that are part of the license agreement, but it just won't be signed until the optionee decides it's time to exercise the option. Finally, the option agreement might not include any terms at all, but only an agreement on the parties to negotiate in good faith the terms of a license agreement. The optionee then pays consideration to the IP owner for the option. It's generally in the form of a flat fee, and in the option agreements signed by UNM Rainforest Innovations, we also require the optionee to reimburse certain IP expenses incurred by UNM Rainforest during the term of the option. If the option agreement expires without being exercised by the optionee, then the agreement goes away and the optionee has no further rights and the IP owner has no further obligations under the option agreement. The IP owner is then free to seek other licensees or optionees for the IP. If the optionee exercises the option, the parties then proceed to the negotiation of a license agreement. So I had some additional thoughts. Like any contract, license agreements are the subject of negotiation. We spend a lot of time negotiating license agreements with third parties. It's kind of a fun exercise. Sometimes it's fun, sometimes it's not. But we have developed some standard templates that address the major elements of license agreements and option agreements. Those have been developed over years and generally are pretty well accepted by the prospective licensees. It always amazes me that different prospective licensees focus on different parts of the license agreement and have questions or want changes to certain parts. Other than the financial parts, those are pretty much left up to the folks at UNM Rainforest Innovations. The legal language and the legal provisions are pretty standard and are not significantly different than most university tech transfer offices would use. But it is interesting that different prospective licensees seem to focus on different parts of the agreement. One might have problems with the provisions dealing with the rights of the optionee or the licensee to participate in the patent prosecution process. While another prospective licensee might be perfectly fine with that, but be more interested in what their rights are with respect to sub-licensing. So it's pretty unusual that UNM Rainforest Innovations is unable to work out acceptable language with respective licensees and optionees. We've been pretty successful over the years in reaching agreement and pretty reasonable in coming to terms with licensees and optionees. That basically ends my presentation. I'm hopeful that there's some questions or comments from someone in the audience that we can address or talk about. One more thing. This presentation really is focused on license agreements that are where the licensor is a university or a research institute. License agreements between commercial entities might look a little bit different than you would get in a university licensing context, particularly in the areas of the consideration. Just keep that in mind. And if you see some licenses that are between two commercial entities, they might look a little different than the license between a university tech transfer office and a commercial entity.